Welcome to Deals and Disputes with the West Webb Law Group.
Hello and welcome back to Deals and Disputes with West Webb, Albritton Gentry. Today's guest is attorney Terrance Dill Jr., senior counsel with West Webb. Terrance has been practicing law since 1992 and brings decades of experience handling business, construction, employment, real estate, probate, and partnership disputes. In addition to representing clients in courtrooms across Texas, Terrance also serves as a mediator and arbitrator, helping parties resolve conflicts more efficiently and with less stress. My name's Kevin Rosenquist, and today we're exploring why mediation and arbitration matter and how they can provide smarter alternatives to traditional lawsuits. Terrance, welcome.
Thanks, Kevin. Glad to be here.
Why might someone choose mediation or arbitration instead of a traditional lawsuit?
Well, mediation and arbitration or SART can be either part of a traditional lawsuit or an alternative, and they're sort of two different things. It's probably easiest to kind of run through what's the difference between a mediation and an arbitration. There's a lot of things in litigation that end in ION. You got depositions, you got mediations, you got arbitrations. So let's see if we can kind of walk through those. A deposition is obviously a testimony that's outside of the courtroom but still under oath that you can use in a legal proceeding. But what we're talking about today is a mediation and an arbitration. So a mediation is nothing more than a formal, moderated settlement conference. And so that's one where generally the parties are already involved in the lawsuit and have retained lawyers. And they'll go to this proceeding called a mediation. It's presided over by a mediator. That'd be me. And so I mediate about 120 to maybe 150 cases a year and been doing that for about 10 or 15 years. And so with your mediation, what you're trying to do is negotiate a resolution to the suit or settle the suit, whatever's in dispute in the lawsuit. And what I've kind of come to realize is that a mediation is basically a risk management exercise where you're trying to resolve the risk of basically going to court and getting a worse result than you could negotiate for yourself in the mediation or the formal settlement conference. Now, contrast that with an arbitration. An arbitration is where you decided, generally by a contract, not to go to court to resolve your dispute, but to present the dispute to an arbitrator. And the proceeding is called an arbitration. And so the arbitrator basically serves as a judge and a jury wrapped into one person. Occasionally you'll have panels of 3 arbitrators, but the evidence and the argument is submitted to the arbitrator or the panel of arbitrators, and then they'll consider what they've seen and heard and read, and then render a decision, which is generally called an award. And so that would be a replacement for going to court and having a trial in front of a judge and a jury. And so those are the two big distinctions. Although the terms sound alike, they're very different concepts.
And with mediation, the mediator doesn't give a judgment. They're just there sort of as almost a facilitator, right?
That's exactly correct. So you've got parties that show up and they're here and here, and the mediator's job is to get you to a deal. Mm-hmm. Whereas in an arbitration, the arbitrator's job isn't to get you to a deal, but it's to render an award.
Right. They're actually going to make that decision. If a deal can't be made in mediation, what happens next?
Well, then generally you would proceed to court. And
okay.
So the mediation is a scenario where the parties can sort of control their own destiny and see if they can't get the dispute resolved rather than going to court and leaving it in the hands of the 12 strangers that would constitute your jury plus the judge.
Can anything from the mediation process be used in court?
Generally, no. So the Texas legislature passed a law in the late 80s that sort of codified what the contours were for a mediation. And one of the principles is that the process itself is confidential. So the positions that the parties take in trying to reach a settlement is confidential, and generally the things they talk about are confidential. Now, if something was not confidential going into mediation, it doesn't become transmogrified into confidential just by going through the process. But what happens at the mediation is confidential.
How does a lawyer decide whether to, or a plaintiff or whatever, decide what to do? If should they go to mediation, should they go to arbitration, should they just go right to a trial?
Well, generally in a civil dispute, it's probably in everybody's best interest to see if you couldn't negotiate a resolution to the dispute prior to going to trial. And it's part of the risk analysis process. The first risk that you want to avoid is putting your clients in a worse position following the trial than you could have obtained for them at either an informal or formal settlement conference such as mediation. And that would include how much is it going to cost in terms of fees and expenses to go to court. Right. But your biggest risk is when you're in court and you're trying a case to a jury, they're almost necessarily going to be 12 strangers. It's very difficult for everyone, including lawyers, to predict what the 12 strangers are going to do. The 12 strangers being the members of the jury. So the way I like to think about it is if you had a group of, 4 or 5 people and you ask everybody to tell me your favorite musical artist and tell me your favorite color. Everyone that you're talking to is probably going to come up with a different specific color, like navy blue, emerald green, ruby red, and they're probably going to come up with a different musical artist. Mm-hmm. This is instructive in talking about juries because you can't predict what's going to be pleasing to the jury's eye or ear. And all jurors do is listen to the lawyers and the witnesses and the judge, and they read or look at the evidence that's come in, plus they kind of judge the credibility of the witnesses by looking at them. And so just like everybody's going to have a different favorite color and a favorite musical artist, jurors are going to be similar. They some things that they see might be more appealing to one juror than the next. And some things they hear might be appealing to other jurors, but not the person sitting next to them. Right. So that's the big risk when you're trying a case to a bunch of strangers. You don't know how they're going to react to the things they see and the things they hear. Whereas in the mediation, before you get to the trial process, you can kind of control what the outcome is going to be rather than leaving it in the hands of 12 strangers.
So then why would someone choose arbitration over a trial? Is that just because you go back to your risk assessment and you say, I feel better about a judge or a panel doing this than 12 of my fellow citizens?
That's exactly right. Plus it's also perceived to be less expensive. And if it's run correctly, an arbitration can be substantially less expensive in terms of fees and costs than a trial. So usually, let's say a trial took 4 or 5 days of trial time in front of the court. Generally, it's at least half of that, and maybe even less than that as far as time in front of the arbitrator. So there can be a substantial savings in time and money by having your dispute resolved in an arbitration as opposed to a courtroom.
So let's talk about this. So you kind of went over what mediation looks like, but let's unpack it a little bit. So you still have lawyers with you when you're in mediation, correct?
That's exactly right. So okay. in the vast majority of cases that are attending or presenting themselves to mediation in the state of Texas, the vast majority of them are cases either already in suit or about to go into suit. And so there are generally lawyers representing the parties to the dispute. And so when the participants show up at the mediation, they'll almost always have their attorney present with them to sort of guide them through the rocks and shoals of the mediation process and frankly, the litigation process.
So in mediation, are the parties together in one big room or they're separate?
When it started off, 30 plus years ago, what they would do is have everybody start off in the same room and then break off into separate rooms. As things have advanced, most of the time people are in separate rooms. And since the pandemic, probably the majority of mediations I see have at least one and often both parties attending remotely via Zoom.
Mm-hmm.
And then what you do is you'll have everybody come into the central room once they've logged into the Zoom app, and you do some introductions, and then you immediately split everybody into breakout rooms.
Okay. And then with arbitration, is it kind of basically just like a trial, only there's no jury?
Yeah, it's a little bit more of an informal process in that you're usually not in a courtroom; you're in somebody's conference room generally.
Oh, okay.
In fact, you can do arbitrations via Zoom as well, and I've done several of those. And there's even an option where they call it desktop arbitration, where the parties will submit everything to the arbitrator in writing. The arbitrator will review what's submitted to him or her in writing, and then render an award based upon what they've read, or if they've sent some sort of video or other photographs, what they've seen. And so, under those cases, those are generally the fastest and incur the least amount of expense from both the arbitrator's point of view and probably the lawyer's point of view. And then, you'll just render your award based upon what you've reviewed, and then submit it fairly promptly back to the. Usually, you'll send it to the lawyers, and they'll disseminate it to their clients.
So you said you typically do close to 150 of these a year, mediations, like as a mediator, right?
Yeah, that would be an in-person mediation. I've also got I'm on panels of some state certain state agencies have a mediation process that are almost always desktop, and I've done thousands of those.
Wow.
And thousands of arbitrations under the similar process. The parties just pick arbitration as opposed to mediation.
How often would you say that that mediation solves it? That you're good, you don't need to move on?
I think my personal statistics are between an 80 to 90% of the cases will settle.
What qualities, in your opinion, do mediators require?
That's probably best answered if I took my mediator hat on and put my lawyer hat on. So there's two things that really annoy me about mediators if I'm the lawyer, and I strive really hard not to do that. The first one is the mediator who's doing something else. We're supposed to be mediating a resolution to your case. So as a general rule, I try only to work on the mediation in front of me, absent some sort of an emergency or something. And then the second characteristic that I avoid at all costs is getting to the end of the session, because mediations are usually you're engaged in sort of hour blocks. So the shortest one is 2 hours, and then most mediations the parties pick a 4-hour block, but you can also pick an all-day one or an 8-hour block. Like I said, the majority of them are 4 hours. But what's annoying is if you get to the end of your 2, 4, or 8-hour block of time with the mediator, and the case didn't settle, and the guy or the mediator says, "Well, thanks very much for paying me a fee. We didn't get the case settled. Goodbye." So I try not to do that.
Wow. Interesting. And you said the first one, you're saying that they're like not fully engaged. They're just kind of doing other stuff while they're mediating.
Yeah, which is incredibly annoying.
That's super annoying. And you can't help but to think, like, are they really able to truly help if they're not kind of engaged, right?
That's exactly right.
Wow. So flipping over to the arbitrator, what kind of qualities do you think an arbitrator needs to have to be successful and to do their job successfully?
The first and most obvious characteristic would be a person would have to be fair, and you'd have to make a decision based upon the evidence that was before you, and try not to demonstrate any explicit bias, and then watch for any implicit bias or sympathy or anything that would deviate from rendering a decision based upon the evidence that you've seen in front of you. That's the most important quality. The second one is you've got to be organized, and there's few things in the world worse than a disorganized mediator or arbitrator. And so those are the first, but the paramount one would be to be fair.
To be fair, yeah. Yeah. what is something or some things that people often get wrong about these two processes that you would love to educate as we finish up here today?
Well, I think it could be a little confusing if you weren't in the legal field as to what's the difference between the mediation and arbitration. So hopefully we've sorted that out for everybody. So because the terms do sound alike.
Yeah.
And but they're very different processes. Both are valuable depending on what you're doing.
Mm-hmm. Yeah, and I think people could probably easily mix them up too and think that one is one thing and one is another. But I guess mediation makes sense. You're mediating a conversation or a settlement or what have you.
Right. That's exactly right. And then the arbitration, that's going to come to generally a final and not appealable decision rendered by the arbitrator or the panel of arbitrators.
Have you ever been an arbitrator?
Oh yeah, thousands of times.
So you've done both of these. Is there one that you prefer over the other?
That's kind of like asking which child do you like better.
Yeah, but we all have an answer for that. I'm just kidding.
Not that I'm going to say.
Oh, that's good. I like that. One thing I wanted to ask real quick is so you said that you like an arbitrator to be fair. That's that's the biggest thing. And that makes a lot of sense. How do you ensure that your mediator is quality, like you said, or that an arbitrator is fair? Like what can you or a client do to make sure they're getting a fair shake?
If I was an attorney advising a client as to the selection of a mediator or arbitrator, they're you're looking for two different things. The mediator, since he or she is not making any sort of decisions or rendering an award or granting or denying anything, what you're looking for there, I would think, is a person that likes to negotiate and is going to assist in the negotiations as opposed to just carrying settlement positions back and forth, right? Then you're going to want someone that's focused on trying to get the case settled, and you're going to have someone that's does not like for cases that they mediate not to settle.
Right.
Those are the three characteristics you're looking for in a mediator. In an arbitrator, what you're looking for is someone that's fair, that will move the process along so it's efficient in terms of time and expense, and then we'll get back to you with a decision, again, that's fair and timely rendered. So those are the big ones. And in my observation, most of those come by sort of personal reputation of either the mediator or the arbitrator.
Makes sense to me. Well, good stuff. Thanks for that, Terrance. Thank you for listening to today's episode of Deals and Disputes with West Webb, Albritton, and Gentry. If you're facing a dispute and want to explore whether mediation or arbitration could help resolve it, visit westwebblaw.com. That's web with two B's to learn more about your options. Don't forget to subscribe to our channel and leave us a review if you found today's episode helpful. Terrance, I really enjoyed chatting with you. Thanks so much for your time.
Thanks, Kev.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.